We'll give him 2 minutes. And he'll join us in a minute, I'm sure.
I'm sure he will.
So first, thank you for my fellow councilors to join this meeting. This is a good cause eviction meeting where we're going to be discussing the eviction law.
That's correct.
And thank you for Councilors Hogan, Nave, Jones-Rouser, Monto, Williams for joining. And welcome to our guest, Sal Curran from VLP. And thank you, Sal, for all the efforts that you put in getting this together. I really appreciate that. Mr. Gary Valerino from MCV Law, and Robert Rubenstein from Hitchcock Legal Aid. So thank you for joining us and helping us through this.
Thank you. Thank you so much, Councilwoman.
So with that, I'm gonna. You want one?
Well, it's okay, Gary and I can
Here
share
you
one. It
go.
won't be
Oh,
a
here you
problem.
go. Here you go.
Okay.
There's no one here. So with that, I'm gonna hand it to you, Sal, so that you can start the meeting.
Absolutely. Thank you all so much for making time to meet with us. After sitting in on one of the previous meetings, I was worried that there wasn't a real clear presentation of the law as it currently exists to be able to base a foundation on what good cause eviction would do. And so I requested the opportunity to have this meeting and reached out to MCV Law, who is certainly one of the best law firms representing landlords in Syracuse. Gary and the different associates and partners who work with him are in Syracuse City Court every day. Rob Rubenstein is one of the, if not the most experienced tenant advocate that appears nearly daily in Syracuse City Court as well. So I wanted to bring both of them. The presentation we have prepared goes over briefly how eviction currently works and what good cause eviction would do. My thought was that we could go through this together, but also if you had questions about how in practice this plays out in court, you'd be able to ask. I've done certainly plenty of representation, but I'm not there nearly as often as Gary and Rob are. So you could ask any of us, and we could give you our opinions about how it plays out. But we have tried to keep the presentation strictly to what the law says. So jumping in, just to provide a brief overview, there are two kinds of eviction: holdover and non-payment. And so I provided a breakdown for the past 6 years of how many eviction filings total there are, how many of those, like what percentage are non-pay and what percentage are holdovers. So non-pay is really straightforward. You owe money, you haven't paid it, and the landlord is trying to evict you for not paying. Holdover is a little bit more complicated. It's called holdover because the landlord told you you needed to be out by a certain date. You didn't leave by that date, and so now they're beginning eviction proceedings. Holdovers can include termination of tenancy, can include lease violations, or objectionable tenancy. And we'll go into it a little bit more, but you do have an opportunity to cure if it's a violation or objectionable tenancy, but not if it's a termination of tenancy at this point.
As I look at the numbers, it seems as though the ratios are shifting. Do
There
you know
is a-
why that's happened over the past 5-year period?
I mean, that's an interesting question. And I will point out that in the numbers, 2020, 21, and 22 are really anomaly years because that's when there were a lot of COVID protections. And in addition, there was a tremendous amount of money, millions and millions of dollars that were being put out through the federal government and the state government in emergency rental assistance programs. And so evictions were essentially put on hold during that time. But still, if you look at 2019 and then look at 2023 and 2024, you can see there, and we don't have the numbers for pre-2019, but I can tell you that going back at least till 2012, when I started doing this work, the ratio was always 90%, 10%, more or less. And it's true, it's now shifted to 75%, 25%. Gary, do you have any thoughts on why you're filing a lot more holdovers rather than non-pays at this point?
Well, certainly during the COVID time, you could not evict for non-payment.
That's correct.
So your hands were tied. So if you had a horrible tenant that was acting badly, bad behavior, bad acts, whatever the like, that's the only way you could get them out, even if they weren't paying the rent, because they do that. And with regard to thereafter, I think it's partly maybe a carryover of that. There was a time period when you could do an eviction and not be on the rental registry. Mm-hmm. But I think that recently changed in the last year or so. So that may have been part of it too, that a landlord wanted to remove a tenant. But if they did a non-payment proceeding, they had to be on the rental registry, but a holdover would not. And so that might be just a trickle down from that.
The law also changed in 2019. Prior to 2019, you didn't have a right to cure for non-pay up to the point of execution of the warrant. So we can go into that a little bit more as we look at the timelines, because it gets a little confusing with the language of how we're talking about, petition, issuance of warrant, execution of warrant. But basically, pre-2019, even if you didn't pay the rent prior to the first appearance, the landlord had no obligation to accept the rent. Whereas post-2019, the landlord now, if they bring you for an eviction for non-pay, they have to accept the rent anytime prior to the eviction. So I think that might also potentially play into it, although I don't represent landlords ever.
I would add as well, what we're seeing, at least in regards to on the tenant side of things, why we're seeing an increase in holdovers, a lot of the tenant protections that came about because of COVID have begun to expire. And a lot of that money that was injected into the system at the state and federal levels, those protections have since gone away, and now landlords are able to bring those holdovers that they were once prohibited from being able to bring in the past.
Mm-hmm. What I will say is that I did pull numbers on other areas, and they have not seen this shift. The rest of the, other major, I pulled it for our continuum of care, which is our, the Housing and Homeless Coalition covers Onondaga County, Cayuga County, and Oswego County. I pulled the numbers for the other counties, and they have not shifted. They have remained with the 90-10 kind of ratio. All right, going on, the eviction process. The basic idea is there are predicate notices. We'll go through what that means. There's an opportunity to cure. In most instances, there's a notice and petition, service of that notice and petition, and then a hearing, and the hearing will result in either a dismissal, an order and warrant, an order of eviction, and an issuance of a warrant of eviction, and maybe a money judgment if that was relevant. Also, sometimes we're able to reach settlements, and sometimes cases are withdrawn by landlords. So what we've done on these next 2 pages is lay out the non-payment eviction timeline. So what you'll see is when the rent is due, which is usually the first day of the month, from that point on, there are 2 notices that need to be served. These are what we call the predicate notices. The first one, the 14-day demand for rent, can be served as soon as the next day, although Gary, I believe, afterwards will talk you through how, in practice, he does that. And then 5 days after the rent is due, there needs to be a 5-day notice saying, hey, you are late on the rent, and both of these now must be served. After that, the notice of petition, and the petition is filed with court, and it must be personally served between 10 and 17 days before the hearing. The court determines the date of the hearing. And again, Gary and Rob can talk more about how our court processes those. Every court is a little different depending on when they hear the cases and what the volume is. At the first appearance, the tenant may request a 14-day adjournment for cause, and that can include trying to seek an attorney, needing to gather necessary evidence or necessary witnesses. And then 14 days later, there's a second appearance, and that's usually the final hearing. At the first appearance, the tenant and landlord can resolve the matter on their own, or if the tenant waives their right to a 14-day adjournment, the hearing can happen on the first day. At the hearing, the judge will take any kind of testimony from the parties, will review photos, videos, any kind of evidence that the parties want to present. And at that point, if a settlement has not already been reached, which I will say in the majority of cases, settlement is reached.
In 14 days.
Well, if not sooner than at that second appearance. But if settlement's not reached, then the judge will make a determination without settlement. An order is the judge saying that either dismissing it or saying that the landlord has the right to reclaim possession. A warrant is then issued. The warrant can either be issued immediately, which would mean the execution goes 14 days out, or they can stay the execution of the warrant due to what we call a good cause stay, where the law clearly lays out situations in which a tenant can say, this would interrupt schooling, I can't find similar housing in this amount of time in the same neighborhood, I have serious medical issues. That's what the 753 stay lays out in the statute. And then if it was for a non-payment, then the judge will determine how much is owed, and they will issue a money judgment. At that point, the landlord then needs to apply for the warrant to the court, bring it to the marshal's office, and from the time that the marshal puts the warrant on the door, unless it says a different date, the tenant has 14 days to move out. And what I'll just note before I hand it over to Gary to talk more about, in practice, how he has experienced this timeline, I will just note that under good cause, there's no extension of the time. None of the timing of it has changed at all. It's just the predicate notices must have the good cause eviction language, and when in the petition also must have the good cause eviction language. And we'll go into what good cause means, but non-payment of rent is a good cause for eviction. So this non-payment isn't hugely affected by good cause eviction. Holdovers are, which we'll go into next. Did you want to talk at all about the timeline at this point?
I do. Thank you very much. And and I don't know how much people know or don't know, but when we're talking about a warrant, we're not talking about an arrest warrant. We're talking about a warrant of eviction.
That's correct.
In that respect. And I totally agree with Sal as far as the rent's usually due on the 1st. And with regard to this 5 and 14-day notices, and I'm going to relay a little bit to the law that she referred to back in 2019, the old law, there was the 2019 Tenant Protection Act drastically changed the way things are done in the landlord-tenant housing court. The old notice was a 3-day, could be given orally. The new notice is, there's actually 2, the 5-day and the 14-day. The 5-day must be sent by certified mail, so the landlord has to incur that cost. And the 14-day must be served just like a court petition, which means that it's got to be, due diligence has to be used to try to serve the tenant personally. If not, at least 2 attempts on 2 different days, 2 different times, followed by regular mail and certified mail. So in practice, you could do the certified mail of the 14-day and the 5-day at the same time, and that's generally what's done by the landlords to save the expense of the postage. So I would say that, oh, I'm sorry.
There you go. Thank you.
No problem. So I've marked off some days here. So it would be 2 days that the rent is past due on the 2nd, and then approximately on the 5 days would be up for the preparation of the service in the 5 and 14-day. Now, the 14-day gives them 14 days to vacate or pay. So now we're up to 19 days if the tenant does neither. Then it takes about 5 days to prepare the petition, file it with the court, and get a court date. The Syracuse City Court assigns a court date. I filed one on Monday. I got the petition back on Tuesday. My court date's January 14th. Okay?
Not
Now
usually that long,
It is not usually. Let me
Because that's 'cause
finish.
of the holiday.
Let me finish. There is a holiday in there,
Yeah.
but it is usually 3 weeks.
Yeah.
It's usually 2.5 to 3 weeks from the time of filing to the time of the court date. So if we take that 3 weeks, now we're up to 45 days for the first court appearance. If that gets adjourned, the 14 days, now we're up to 59 days for the second court appearance. If a warrant is granted on the 59th day, okay, so now what happens is the landlord or their attorney has to contact the marshals. The marshal then prepares the warrant, sends it over to the court for the judge to sign it. Then it gets back to the marshal. Then the marshal goes and serves it. So that all takes approximately 5 days, sometimes a little shorter, sometimes longer. So that's the 64th day now that the warrant's served. The tenant has 14 days to vacate on the 64th date, so that brings us up to the 78th date that the warrant's up, and the marshal does not go out on 12/01 on the 14th day and enforce the warrant. So there's a time that the landlord needs to contact the marshal. They arrange a mutually convenient time to meet at the premises, to change the locks, and to secure the premises and turn it back over, possession back over to the landlord. So add another 5 days. Now we're up to, I count 82 days, okay? And that's if there's only one adjournment. Sometimes there's more than one adjournment. Sometimes the court schedule doesn't allow the 2-week adjournment to be exactly 2 weeks. So that's a realistic time frame, I would say. Prior to 2019, I could tell someone who came to me on the second day of the month that I could probably turn around their entire eviction process, including enforcement of the warrant, within 30 days. Now, I'm looking at within 90 days. Yeah. So that's a realistic viewpoint of the process from soup to nuts.
Yeah, none of that changes with good cause. That's
that
just
was-
the
that was-
way
I
it
was
is.
gonna ask.
Yeah, that's the way it is, and it's been that way since 2019. Do you have anything you want to add to that?
No, just simply that, yes, the good cause legislation does not affect any of the procedural aspects that are presently in place with how an eviction takes place within the state of New York. It simply adds essentially a reason as to why a landlord is bringing an eviction against the tenant.
That's correct. Yeah, the landlord has to tell you under good cause, but we'll get into that. Let's talk about holdovers.
If I may, one more thing.
Because we're about to get into it.
It does impact it, even without the good cause law being passed. it does impact the process, because for every notice that gets served on the tenant, the landlord must, and I, as the attorney, must attach to the court petition the 5-day notice, 14-day notice, the 6-page good cause law, which simply states that the good cause law has not been adopted in this jurisdiction and therefore doesn't apply. So we have to attach that to every single piece of paper. And for a petition for 2 tenants, we have to have an original, a copy to be served or posted, 2 more copies to be mailed, regular mailed, certified mail. So you're talking approximately 50 to 75 additional pieces of paper that have to be copied, printed. It's increased weight for postage. So the good cause law is impacting landlords right now, even though it's not adopted.
I didn't think they had to do that. I didn't think, because you only have to attach the good cause notice if you want to be exempt from good cause, right? So there's nothing, if the jurisdiction hasn't adopted good cause,
No,
you shouldn't have to.
You have to
The
adopt it.
statute does require, as of right now, that under real property law, section 231C, that with every notice sent to tenants by the landlord or by the landlord's attorney or agent, the good cause eviction law notice, which a copy has been provided for the council, must be completed whether or not good cause has been adopted. It's
interesting. I
It's
didn't
essentially
realize that.
a number of boxes that are ticked or marked.
Yeah.
Strangely enough, it doesn't say what happens if you don't attach
Right,
it.
I was going to say, I don't think there's
But
any
it says you have to
enforcement.
attach it.
I don't think there's any enforcement, but you're right, I didn't
Just
realize
so
that.
you attach this, and who ends up with it? The good cause?
The tenant.
The tenant.
The tenant.
The
And
tenant.
So does this cause any confusion? I mean, obviously, we're giving them a paperwork that doesn't apply to them
Sometimes,
right now.
sometimes a tenant might call me and say, why'd you send me this other paper along with the notice to pay the rent? And I say it's required by law. At this time, you don't have to worry about it.
Yeah, and that's
I
nothing
would-
that this council can affect.
I would simply
Yeah.
say that
Yeah, that's in
really
place
it's essentially to address your question, Councilman, is this
Counselor.
Counselor.
Councilman, don't get in
Sorry.
trouble.
Apologize for that.
You know, I get in trouble sometimes.
Apologize, Counselor. The purpose of the notice really kind of, if there is confusion on behalf of the tenant, it's for the court to see that it's been done. As Mr. Ballerino has indicated, there is no provision in the law to say what does or does not happen if this is not included. In effect, there is no penalty on the landlord or their case if they fail to attach it or simply forget to do it at one point during the process.
So, I mean, I guess what's interesting, because I didn't realize this was already required, is that actually then that has absolutely no impact whatsoever because you're alretty having to do it. So it doesn't,
Well,
adopting
you
good
have to
cause
fill it
doesn't
out.
actually affect
Yeah.
that at all.
Fill it out differently, and if you have good cause.
Right, you'd have to check different boxes.
Yep.
Okay, so holdover eviction. This is different as well. So this is when the tenant, usually what this is, in most of Syracuse, right, is month-by-month tenancy. There are some full-year tenancies, but most is month-by-month. So what this says is that you've got to give notice depending on the length of time that the tenant's been living in the property. So if they've lived there less than a year, you have to give 30 days notice telling them that the tenancy is being terminated. If they've lived there more than a year but less than 2 years, you have to give 60 days notice. And if you've lived there for more than 2 years, you got to give 90-day notice. And that's more than 2 years. It doesn't matter if you've lived there 2 years or 30 years. 90 days is the max. Then the tenancy ends. The landlord can't accept rent between when the date it ends. So say it ends December 31st, and they file January 5th. They can't accept rent between on January 1st, 2nd, 3rd, 4th, or 5th until they've filed their petition. The petition, once it's been filed, they can start accepting occupancy.
So can you go into, if the 90-day notice is filed, if you send somebody a 90-day notice and they immediately stop paying the next day, where are we on the timeline?
Well, they
stop-
could then choose to file a non-pay instead of the holdover. These are alternates. You can't do both. You got to do one or the other. So you could do, you file the 90-day, but then they stop paying rent, and you say, never mind, we're going to go ahead and do a non-pay.
I was actually going to address that because I would estimate of my clients at least 50% of the tenants, once they've served with a termination notice, they stop paying the rent. And depending on whether it's a 30-day notice or a 90-day notice, kind of depends on whether or not the landlord would choose to then do a non-payment proceeding instead of waiting the 90 days to do the holdover.
So how do you determine 30 from 90?
It's how long the tenant's been living there.
Oh, that's
Less
right,
than a
you just
year.
said, yes.
Yeah, less than a year is 30. More than 2 years, it's 90. So then, same thing, notice and petition. It's got to be served, personally served on the tenant between 10 and 17 days before the hearing. Again, first appearance, the tenant may request a 14-day adjournment to try to get an attorney or to get necessary evidence. Answer can be written and oral, and at the second, or you can, reserve the answer for the second appearance if you need to get an attorney. And then the second appearance is usually a hearing. I didn't give the long list of defenses that folks have regarding these, but I would say the most common that we are seeing is if we're arguing that it's retaliatory because of codes. But
Yes,
you didn't say that?
Yeah, I tend to agree. And also, for some reason, there was actually somebody who wrote something in this Sunday's newspaper about good cause law and referenced retaliation about a half dozen times. If you read through the good cause law, I don't think the word retaliation is even in there.
No, we already have laws about that.
The Tenant Protection Act in 2019 changed the retaliation law, if you will, with regard to that. So this has, in my opinion, good cause really has nothing to do with retaliation. I think the tenants are sufficiently protected. And if you want me to summarize that retaliation law, I will. It's that if a tenant makes a complaint, whether to the landlord or to codes, and the landlord attempts to evict the tenant within 1 year from the date of that complaint, then the burden is on the landlord to show that that eviction was based upon a non-retaliatory motive, which changed the law before because the law prior to 2019 was the tenant had the burden to show that it was retaliatory by the landlord. But now the landlord has that burden to show that the motive is non-retaliatory.
But the tenant has to assert the defense first, which unrepresented tenants usually do not know they have a right to do.
That happens when they make a complaint to the codes department and then the violation, there's an actual code violation, or just the complaint.
It can be a wide variety of reasons. It can be a complaint to the landlord, but there usually needs to be documentation about it. Yeah, I mean, we could do 30 minutes just on retaliation. So I think we'll try to move along from that, but we could come back and talk more about that.
There are several reasons, of which a report to codes is just simply one of them. It's the most common one that we hear tenants bringing to our office, as well as I'm sure the other legal aid agencies as well, when the defense is asserted. If anything, I would say that one thing that in my understanding of this statute, that good cause does is perhaps reduce the possibility of a retaliation argument even being available, since a landlord is now providing in the good cause eviction law notice, that is, again, unfortunately, that 6-page notice, providing the reason why the landlord is bringing the eviction.
Yeah, the non-retaliatory.
That does stifle, at least on the tenant side, our ability to utilize that defense as effectively as we have been able to in the past.
Really good point.
Yes, I doubt if a landlord's going to put if it's adopted in the good cause form, that I am evicting this person in retaliation for calling codes.
Yeah, I don't think that's
that's
one of
going to
the
be in
check
there.
boxes.
That's not going to be in there.
And
And
so
I
then,
just want to point out that,
Yeah.
that on that portion of the retaliation part, I think you spoke to what we have been saying, that this is already in effect, and it was the tenant rights groups that are saying good cause needs to be passed because of landlord retaliations. And that's already in place, just like you just said, that they already are efficiently protected in that form. So it wasn't us, it's the tenant rights groups who have said that.
right, and we're responding
We've stressed
to that.
that over and over, that those protections are already there. So
Yeah, I think
just
the
wanna put
problem
that
that
out.
we see, and the reason the tenant groups keep bringing it up, is that we have all had a lot of cases where the landlord says it's just because I want them out, but as soon as you start looking at it, the timing is very suspicious, where the client called codes and literally within 48 hours, they got the termination of tenancy. And so that's why you're hearing it, is just in practice, that's what we're seeing. And then, you know, if the tenant's not represented, they do have a very difficult time presenting that defense, because it is an affirmative defense. It's not an automatic thing. The judge doesn't automatically inquire without good cause eviction. The judge doesn't automatically inquire, what is the reason you're evicting, you know? So that's, I think, why tenants feel that it would protect them greater, because right now it's assumed that it's non-retaliatory, but there's no reason. It's kind of like, you know, imagine you were
there's nothing more
fired.
to measure it against.
Yeah,
though.
like
So
imagine you
there's-
were let go and you didn't know why, and you're left wondering, what the heck did I do with this job that caused me to not be able to stay in my job? It's like that. It's, you know, you don't know what happened if it's without good cause in most instances.
I
Is there
think
a registry that landlords have, like of bad tenants, with a long history of not paying their rent, or there had been an eviction, or they damaged it? In other words, they have a list that this is a high-risk tenant.
Well, they're not
Do they have
supposed
any of
to.
that? They're not supposed to.
Yeah, it's
That's
prohibited by
illegal.
by law. But what we see and what the tenants tell us is that many landlords require a reference from your previous landlord, and so you'll get situations where there's a holdover, tenant, you know, ends up being evicted, and again, it's without cause. You know, there's no reason for it, but then the landlord won't give a reference,
Right,
and
I'm
so
sure.
you can't move
Right.
on.
Well, I'm just curious because like the tenants union would have a list of bad landlords, I'm sure.
We
You
don't
know,
have
that-
any official
so
lists
there's
either
nothing.
direction.
Okay.
Yeah.
That's why I asked
Yeah,
that
the
question.
2019 law made that improper,
Yeah.
illegal, if you will, to
Okay.
do.
That's
You
right.
can't even go to the courthouse and look it up.
All right.
No, yeah, you can't even foil the
So on
the
both
names.
sides, you can't do that.
That's correct. The court won't.
Well, I
let
don't
you
know
foil the
about, I
names.
guess tenants could make a list of bad landlords if they want to. There's nothing to prevent them from doing that.
It's hard
under
to
the
know
law.
who the landlord is. Most of them have independent LLCs.
what I think the council should really consider, I think overall, in terms of as we're going through all of this and keeping in mind this particular issue, is the law is possibly designed to allow for a measure of stability, especially for those tenants who are on fixed incomes. And now that's whether you're dealing with an elderly individual who is simply drawing on Social Security or a pension, or an individual or a household who is simply, their only means of income is from some agency that is providing a fixed amount of income, and addressing whether or not rent increases that are being proposed are in fact reasonable. And I think that that's something that really the council ought to keep in the back of their minds while considering whether to adopt this, because that's really my take on what the thrust of this legislation is trying to get at.
Yeah, what Rob's referencing here is, if you skip ahead to page 13, what good cause does is it establishes what a reasonable rent increase is. And it bases it on the Consumer Price Index. And it says that a reasonable rent interest is 5% plus Consumer Price Index, but not more than 10%. So you can imagine if you're renting a single bedroom for $1,000, you're not allowed to increase the rent by more than $100 a month in 1 year. And the rate for the previous year will be published every year by the HCR. So right now, outside of New York City and Long Island, that percentage is 8.45%. So if you are renting a $1,000 a month apartment, the landlord can't increase the rent by more than, under this law, the landlord wouldn't be able to increase the rent by more than $84.50 per month in 1 year. Now, currently, the law stands that a landlord can increase the rent by any amount that they want, which is why we're seeing some landlords increase the rent by 50% or 100%. So, going from $750 a month in rent to over $1,400 a month in rent. And currently, what the landlord has to do is give that same 30, 60, or 90-day notice about the increase, and there's no cap at all. So it's really entirely market controlled, not at all regulated. We already went over this current law about the timing, so let's go into page 11. Who does good cause eviction cover? So this is a list of who it does not cover. It doesn't cover premises owned by a small landlord. It doesn't include owner-occupied buildings with no more than 10 units. It doesn't include where units is subletted. It doesn't include units that are 245% or more of the fair market rental value. Does not include hospitals, dorms, or religious facilities or institutions. It doesn't include units that are occupied solely as an incident to employment, so like farmhouse kind of situations. It doesn't include units that are otherwise subject to regulation of rents, which we don't have, but down in the city they have a lot of rent regulation. It doesn't include units where the unit must be affordable to the tenant, so it doesn't include affordable housing. It doesn't include co-ops or condos, which again, not so relevant up here. We don't have a lot of those. And importantly, it doesn't include any building built after 2009.
Related to the what does good cause cover, we've heard scenarios put forth related to the sale of a property. Can you walk through what would happen if a property is up for sale, purchased by a new individual? Where does the tenant stand in that situation?
Yeah, tenancy continues regardless, like a lease or a tenancy continues when a property is bought or sold. So the new landlord would have to do the same procedure that a previous landlord would. Anything you'd add to that?
Yes, we're skipping around a little bit,
Yeah.
but I would say, and we have some realtors in the audience here, that, boy, I don't know what the percentage is, but it's pretty high, that buyers of property do not want to inherit tenants, plain and simple. That's the way it is. Customarily, when a landlord purchases a property, or it could be an owner, well, owner-occupied, obviously, they don't want a tenant. But when a landlord purchases a property, almost all the time, they want to go in, they want to rehab the place, they want to upgrade it. Will it result in probably an increase in rents? Absolutely, because they just put thousands, sometimes tens of thousands of dollars to redo bathrooms, kitchens, appliances, flooring, whatever else. So again, I don't know if the percentage is 90, 80, but it's up there. So a lot of evictions get done, and I've done a lot of evictions when there's a sale pending, and the sale is contingent upon the property being vacant, and the sale is held up because of the eviction proceeding, that the tenants are still occupying the premises.
Right. The amount can be increased by the current landlord if they are doing improvements that are beyond regular, like special capital improvements and things like that as well. Like that cap on the increases under good cause eviction can be waived if the landlord is doing substantial improvements.
But that portion has to go before the judge, correct?
Well, it only goes before the judge if the landlord is trying to evict the tenant based on
No,
yes.
I'm not talking about eviction. I'm saying
Right.
as far as the increase due to capital improvement, that's going before a judge?
No, it only,
So if I improve beyond the 8% and I want to raise the rent to support what I've done, and the tenant is saying, no, they don't want to, then I have to formally try to evict because of that?
that's correct.
Oh,
Yes.
okay,
Yeah,
okay.
and that's when the judge would determine. So if you're trying to evict based on non-payment of rent that goes above, this is again in a good cause world, right? We're imagining good cause has been passed. Say you want to increase the rent by 20% this year. So you've got a $1,000 apartment, you want to fix it up, you're going to fix it up, so you want to increase it by $200 a month that next time. The difference between that 100 that's allowed and that 200 that you want to do, if you're basing the non-payment eviction on non-payment of that portion, then you would need to, and you were subject to good cause eviction, right? You're not in a house that was built after 2009 or whatever.
I just want to
Then the judge would need to determine that it was.
And how would the judge determine that? That's what I'm
You
trying to
would
get to.
provide proof of the improvements you were doing.
That's what I was asking.
Yeah.
And you said no, that they wouldn't have to.
Right, you don't get it pre-approved. Like a judge
No, I'm
doesn't
not saying a
determine it ahead
pre-approval.
of time.
I'm not saying a pre-approval. I'm just saying
Yeah.
that.
So
you have to-
the practical result
Yeah.
of it would be that the landlord would present to the tenant a new lease for that greater amount of rent. The tenant would say, I'm not signing a lease, that's too much. The landlord would probably say, at least I would say, and I'm a landlord, the landlord would probably say, well, in that case, you can't live here. So the tenant will pay whatever the current rent is. The landlord would serve a termination to terminate the tenancy based upon the 30, 60, 90-day rule, and then go to court on a holdover proceeding. And the tenant would then raise that defense that says, well, the landlord wanted to raise my rent too high, in excess. It was unreasonable according to the law. And then that's what would turn into probably a trial. Now the landlord would have the burden of bringing in his receipts, his documentation, and everything else to show what he did to the property to merit the increase in the rent, and then the judge would have to decide if that was appropriate.
Right, exactly.
Can I ask a question? Mr. Ballerino, you were mentioning that if somebody's buying a property and they don't want to inherit the tenant, so it delays the purchase, right? So is it also through that same 30 to 90 days, or is there a different kind of timeline if it's an acquisition?
It doesn't change the timeline whether the reason for the landlord wanting to evict a tenant. That doesn't change the timeline because they're selling the property.
That's right.
But I also want to address one of these that are not covered by good cause, and that is the units built after January 1st, 2009. The other ones, I guess, seem logical. This one didn't. I'm thinking, why do units built after 2009 not qualify for good cause? So based upon my looking into this, at first I thought maybe some politician involved in this owned a lot of properties built after 2009.
That's kind of what I assumed.
So they were excluded. I didn't know. So anyway, I looked into it a little bit, and from what I found, if I'm accurate, is that it was mainly based upon the fear that it would negatively impact future housing development, primarily with banks and financial institutions being willing to loan money that are subject to this law.
So it's a bank lobby, is what you're saying.
I don't know if it's a bank lobby. I'm just telling you what I
Yeah.
read, and that's what I've been told was the reason for excluding those after January 1st, 2009.
I guess you can say it's good that it won't have any impact on new developments, is what you're saying. But
Yeah, but it tells me that the writers of this law agreed that this negatively impacts the ability for property owners to get financing. That's what it tells me.
I mean, what's interesting is that this law is a very watered-down version of what was initially introduced. So there were a lot of compromises that happened in the course of the passing of this law, including the local opt-in. That was not originally included in the original draft of this bill.
I have a
So
question.
they sort of kicked the can down the road on that.
We have so many homes that are in tax arrears, right?
Yes.
They're very old. So how are the tenants being protected if they know their landlord, and maybe some of the tenants were behind paying their rent, just gave up, gives it to the land bank. Now somebody buys this property. Is the tenant being forced out? Is the new owner going to say to the tenant, I'm raising your rates?
Yeah.
How does, just to pay the back taxes, how does that happen?
I just want to say
I don't
that-
think I really feel like addressing land
I'm
bank cases
curious.
right now, if
And-
that's
No, but
okay.
any
Because
other
I kind of want to
property-
get through the rest
No
of the
property is
presentation.
given to the land bank, so that there's a whole
Yeah, it's a
process through the city.
foreclosure.
So
it's
it
a
goes, what
foreclosure
is, so is
process.
the tenant protected?
It's a really different situation when a foreclosure is involved. It's very different than a sale. Tenants have far fewer rights under a
So we
foreclosure.
want to make sure the tenant
There's
is
not,
protected.
essentially, there's not a landlord-tenant relationship.
Okay.
Become a
between them.
squatter.
Just like if I have a house that's
true.
empty right now, it's vacant, and someone breaks in and starts
Yeah.
living there, they're not a
That's right.
tenant.
Yeah.
They don't
Well,
have tenants' rights.
That's right. Once a foreclosure takes place, everybody becomes squatters.
If someone is in the property that the land bank is acquiring, they work with that individual as a renter for a time period. And-
As
and-
an
and they
occupant.
offer-
As an
yes,
occupant.
as an occupant. And
Not
they-
a renter. They don't establish tenant rights with the,
They collect
tenants.
rent, correct?
they collect occupancy.
Okay, however you want to call it. And they also.
It's
and
a
they-
difference.
They
So there's
also
a
give
difference
them
in
the
terms of your
ability to
rights.
purchase the property. They have first right to purchase as well. So that's
Yeah.
a completely
we've done-
different topic.
Yeah, we've done a lot of advocacy over the years regarding, like, the tenant rights groups. There was a period when it was just a 10-day notice and everybody was getting kicked out. And then we did advocacy with the Land Bank and the Common Council about 10 years ago to set up a process where the council helped fund home relocation for the tenants. So it's been, the current procedure is much better, I will say, but it was not always that way.
Well, thank
So
you.
Sally, how do you define small landlord? What is that?
Right. So that is one of the only parts. There's only two parts of good cause that if you so choose to adopt it, that can be decided by the council. Everything else is already predetermined in the law. One is the definition of small landlord, and two is the percentage of fair market rent that is exempt from good cause. So right now, the law says 245% of fair market, above 245% of fair market rent, the council could say 300%, whatever. But small landlord, the law says that the municipality that's adopting good cause eviction gets to determine what it is. It means that the landlord owns no more than the number of units that the council determines. And that is regardless of whether they own them in Syracuse or Syracuse and DeWitt or Syracuse, DeWitt, and Cicero. It is in the state of New York.
Statewide, yeah.
Yeah, state of New York. And it only looks at the natural person, so the actual humans who own the property. And this is relevant because the vast majority of the properties in the city of Syracuse, I would say at this point, at least of the ones that are bringing evictions, are LLCs, is what we see. And so what this does is it pierces LLCs, and it says you have to say who actually owns that LLC. So is it one person? Is it two people? Is it three people? And it looks at each of those human beings, natural persons, to determine how many units are owned.
I would add the caveat, though, that this only pierces the LLC only if that LLC is trying to claim the exemption of being a small landlord. If the LLC does not try to claim being a small landlord, they would be still subject to the good cause law. They would not have to then disclose who all of their members are or what other properties their members own.
That's correct.
Well, with regard to the small landlord, obviously, the landlord's side would want that number as high as possible if this law was adopted here. I will tell you, we could learn a lesson through COVID. The small landlords, the kind of mom and pop landlords, I think took it on the chin big time during the COVID moratorium. They were the ones that, you hear living paycheck to paycheck. A lot of these landlords were living monthly rent payment to monthly rent payment. They had insurance, real estate taxes, school taxes. They were still obligated to do maintenance and repairs to the property, even though they weren't receiving rents on it. So they were the ones that were impacted the most. So I obviously would think this number, if the law is adopted, that this number be as high as possible.
So the highest it can be is 10. That's how it was adopted in the city of in the New York City and under the law. Every other municipality that has adopted it, I think there's 8 as of today, has adopted it as 1 because of this question of the difficulty determining who is behind the LLCs
Because
and whatnot.
You can own various.
That's right.
LLCs.
And then I just have to say, if we're gonna take positions about who took it during COVID. I would say that there's a couple of different really, I would disagree with that analysis. One, a tremendous, I mean, millions and millions of dollars went out to the landlords from our taxpayer dollars and made the landlords whole or very close to whole. And then the other thing I will say is that I do think that.
Okay, so
Why don't we let a city councilor talk for a little while?
there was a lot of landlords that never received payment, and then the portal closed. So do not make blanket statements that all landlords were covered.
Fair. Okay.
I guess
The
my-
other thing I would,
If I may, my statement was that the small landlord was unable to absorb those losses as great as an institutional landlord.
Sure. And then the other thing I will say is that if you look at the homelessness numbers, if there's any question about the tie between eviction and homelessness, all you need to do is look at the numbers of evictions during the time of COVID, which were put on hold due to that stay, and the numbers of homelessness in the city of Syracuse, which at that time hit the lowest rate of homelessness that we've ever seen in this city. And now that evictions are back in full swing, we have the highest rate of homelessness that we've ever seen in this city, and certainly the highest rate of first-time family homelessness that we have ever seen in this city.
So what does the city do? Have you guys all read our housing strategy?
Yes.
You know what it costs like to keep up a house? I mean, like a
Inside of
Yeah,
Syracuse,
well,
I too
it's-
know
No,
how
I'm
much
saying
it
it's
costs,
$1,800 a unit
Yeah.
to maintain that unit. It's only
That's
8% of the people pay over $1,500 a unit in the city, and we've done that study. And we've had what you talked about is deferred maintenance for years and years and years because 70% of the houses
That's
are
right.
70% of the houses were built before 1970. So what does the city do? I mean, we want to maintain obviously
Right.
that housing.
I mean, I'm
and so
firmly
how
in
does
support.
let me
Yeah, but I
let me
wanted to
talk a little bit.
Okay, I just wanted to
okay?
give the
No, I mean,
solution.
whoa, you got a solution?
Yeah,
Because some of us wrestle with the solution, try to find the solution. It's a very difficult solution because you talk about homeless. I know there's 2,000-3,000 people, unhoused people in this city every single night. But we also send out a fire department 2 or 3 nights a week sometimes to battle some of the housing fires we have in the city.
Yeah.
There's a lot of danger out there, and we also have people living in substandard apartments. And what you're
Absolutely.
talking is that a guy takes over or a woman takes over a house, and you're limited in how much money you can put into it. And I'm thinking about why even buy a house in the city of Syracuse? Why should I put money in the city of Syracuse when I can get a house in Marcellus or Skinny Atlas or Clay or North Syracuse and not have to have another layer of regulations called good cause to deal with, where they actually send out a paper even though it's not in effect in that municipality.
Well, they have to do that in every jurisdiction
I know.
then.
They do.
So.
Well, they do it, yeah, because the state decides to give us more paperwork. So
Yeah.
what does a person do? Where do the investors go? I tell you what, they're not going to go in the city of Syracuse.
Right. So, Counselor, what I think the city needs to do is make a very serious commitment to invest a substantial amount of money to give to landlords to make repairs. And I think the city needs to work with the county so that they don't build an aquarium and they invest the money in housing.
Well, you can talk
instead.
about aquariums all you want. We're building a 550-unit housing project up there in Syracuse Developmental Center. That's to make it work. The city of Syracuse just passed. Well, we're going to have to approve it, a 30-year tax agreement, pilot agreement. There's so many gaps. It is not easy at all in finding investors to build in housings. And now what you're doing is taking the incentive away from a lot of small-time investors. I represent a lot of small landlords.
I hear that you represent them, and it certainly comes across in your statements. I'm saying that I do believe that this city, as a taxpayer in this city, we have an obligation to try to make a commitment on a very deep level to improve all of the housing. I think the housing study was the very first step. I think that the HUD funding that goes out every year is wonderful. We need to...
We should build more housing.
No, I
correct?
think we need to put money towards improving the properties as well. We need to make money available. But what I'll say is,
just formed a housing strategy
now
committee.
we have the ability. We have the county has that windows and doors process.
You know what?
Listen.
You're getting the
county
governments mixed up here
has
a little
free money available council to make improvements to abate lead, and landlords aren't applying for it. So what we're talking about is a willingness by landlords to not make repairs. That has nothing to do with good cause eviction.
Counselor, if I may,
You guys got two, we got one, right here, right? 2-1? Because you probably need two to convince me.
you're right. The reason that I think, at least on the tenant side of things, we would ask that the council consider putting the limit at 1 unit is to make it so that everyone is subject to it. One reason why the council might want to consider that is for those reasonable rent increases. Councilor, you were talking about increase or improving properties. I don't think you and I will disagree at all that the properties in the city that are mostly rental are in bad shape and that they need a lot of repair. What we need is we need an ability of landlords to be able to generate the revenue and the income from those rentals to be able to make repairs. Now, the reasonable rental increase that is allowed in this legislation and which can be made over several years will allow for landlords to bring up those rents to a level that will allow them to start making repairs to the property, improving and maintaining the rental property that is available within the city. Because again, it is a difficult question. And it is one which over the nearly 10 years that I have been doing landlord-tenant eviction cases, I have not been able to see how a solution can be found. It takes both sides of this argument to figure out how to do it. And those reasonable rent increases is going to be able to provide that ability to make those repairs viable.
That's correct. Again, I mean, if you look at page 14, we list out the factors, structural, the significant repairs that are allowed, that allow a larger increase of rent beyond the CPI plus 5 are structural, electrical, plumbing, or mechanical system that requires a building permit, abatement of hazardous materials, not minor repairs, So, I mean, it's even built into the law to allow increases. I know we're nearly out of time, so I did just want to hit.
Can I just say one thing to what you both were just saying? I just want to point out the fact that even for landlords to do any repairs, we have to have permission to get into the property from the tenant. And so if a tenant does not allow a landlord in a property, I think that needs to be noted that tenants don't always even allow the owner of the property inside their unit.
That is
So
good
to
cause,
do some
Counselor.
repairs,
Yeah, Counselor, that would be good cause.
becomes difficult as
Yeah,
well.
as we go through the good
And
cause.
then there's an increase on the number of repairs that need to happen. When something could have been fixed when it was a simple fix, and now I have 2, 3, 4 other things that need to be fixed because I wasn't allowed into a property when I could have done it on time.
Yeah, Counselor, so going to page 16, that would be good cause for eviction. Breach, so that would be unreasonable refusal
I'm not
of
talking about
access.
an eviction process. I'm clearly just stating the fact of money when you're talking about repairs and the amount that I guess you have deemed acceptable to increase a rent based on a repair. And sometimes that's just not true. You don't know what every repair is. Not you, but people don't know what the repairs are because something that I could have fixed early on has now escalated to a whole nother charge because the tenant is not allowing me into the property.
Right, but Counselor, you have the right to evict somebody if they unreasonably refuse access. You have that right now, and you have that right under good cause. So what you're talking about, I can understand your frustration. That would be incredibly frustrating as a landlord to not be given reasonable access to the property to make repairs. And that's already taken care of under the law. That's not actually at all relevant to this particular discussion regarding good cause.
I think one thing with regard to this, and I hear the access issue all the time, primarily with rental registry, that the city can't get in. They set up appointments. They won't let them in. They can't get the rental registry certificate, and then at court, they raise it as a defense, saying there's no rental registry. And then we're trying to avoid litigation. as the landlords and hopefully as tenants. And I don't think this good cause does that. It indicates that you could show that you did the repairs. You could show this. Well, it's got to be all shown in court on that. And I guess we're running short of time, so I wanted to get a couple things across. Number one, I don't believe the good cause law limits a municipality to just 10 as the maximum amount of small landlords. It does not give a limitation. It just says that the number of units established as a maximum amount can own in the state, local law of village, town, or city. So I don't think there's any maximum, number one. And I want to address two items as to what the good cause does not show, does not cover, and that is persistent. It does cover non-payment of rent as a good cause, but it does not cover persistent late payment of a tenant. And that is a huge problem. As you indicated earlier, if you bring a non-payment proceeding, the tenant has until enforcement of the warrant to pay up. I have a court proceeding this afternoon. This is the fourth time I'm going to court with the same tenant for the same landlord in 2024. Each time we go to court, we get the warrant, the tenant comes up with the money before the warrant's enforced. So this landlord is paying me 4 times to do an eviction proceeding. So what's his recourse now if this tenant comes up again with the money? He's got to serve a termination. But chronic late payment is not a good cause for termination of a tenancy. It's only non-payment of rent, not chronic late payment.
Well, he has another recourse, Gary,
secondly is,
right? He has another recourse. He has small
what's the
claim-
recourse?
He can go to small claims court.
Small claims court for the late fees?
Yes.
Okay.
And
more
for the
more
attorney's
litigation.
fees.
More litigation.
And for the
more
attorney's
litigation.
fees.
More litigation. Get a judgment that may be uncollectible.
Because they're
Again,
poor.
it's more litigation. You're steering them toward more litigation. That's what people don't want is more litigation.
I think the issue of chronic late rent is addressed as a breach of the lease, and also there are statutes under the Housing Stability Tenant Protection Act that did address.
Well, it's not under
what-
good cause. It says non-payment. It doesn't say late payment. And
So
it also
Elaine-
doesn't say if the landlord wants to sell their property.
I think the issue regarding this chronic late payment that Gary's talking about is landlord-tenant court is not actually a collections court. That is small claims in the civil part. Landlord-tenant court really is only about possession of the property. And so if there are costs that are incurred that are not rent, such as attorney's fees or things like that, there is a venue to go after that. It's just not landlord-tenant court, because that's about possession of a property. So when he says there's no recourse in landlord-tenant court for it, but there's recourse, you just would have to do it.
That still keeps the tenant in the property.
That's correct.
It does nothing else.
That's
the
right.
landlord will get if they did go through small claims court, pay the money, take the time, they'd get a judgment against the tenant and then try to have to collect that judgment, garnish wages. If they're on Social Security disability or something that's non-garnishable, the judgment goes uncollected.
That's
So
right.
it doesn't solve the problem of removing the tenant that's a chronic late payer.
So let's just run the other good causes. Breach of lease, nuisance. So I know when we were in the landlord section, they talked about a person who brought in a dog that wasn't allowed under the lease. That'd be a breach of lease. The dog was bothering other tenants. That's nuisance. Illegal use, unreasonable refusal of access. Tenant fails to agree to reasonable changes to the lease at renewal. Tenant interference with the landlord's or other tenants or occupants' safety and comfort. Use for the owner or the immediate families of the owner, and it gives a definition regarding that. Demolition of the housing accommodation, intention to withdraw the house from the rental market. And all three of those ones of these good causes allow a tenant who determines the landlord lied to sue the landlord for damages. So if the landlord's going to be going out there, there's going to be more litigation. So, I think that most of the concerns that the landlords had raised last time actually fall pretty neatly under exceptions to good cause. And so, I guess and it goes on to talk about the notices and things that we wanted to provide to you, but I guess at the end of the day, what you as counselors need to decide is what's the underlying interest that you have? Is it to keep the community housed or is it to make sure that landlords make the maximum profit? And that's my position as a tenant advocate, of course.
Definitely your
But I mean, that's my position. I mean, Gary got to just say his position, and that's my position. And, you know, the city of New York decided that it was more important to ensure housing stability and predictability for the tenants than it was, you know, to make it so that people can, you know, be kicked out for chronic non-payment of rent. That's ultimately up to you. Today, what we wanted to do is provide you with the law so that you know very clearly what it is that you're changing, which is a notice requirement, and you're changing, if you do good cause eviction, you're changing it so that a landlord has to explain why they're kicking somebody out. That 25% of evictions in holdovers right now, they don't have to know why they're being kicked out. That's 656 people this year, households, not people, households. Don't have to know why they were kicked out. And under good cause, it's going to say they have to have a reason. And it's true. There's a couple of reasons Gary pointed out that aren't included in good cause that he would like to
But
see included.
those holdovers, Sal, yeah, to be fair, those holdovers may also be for objectionable tenants, where their tenancy was
That's correct.
terminated
But
and
that's
then
like
holdover.
almost none. We almost never see those.
Well, I
You
see them a lot, unfortunately.
You only see those when
Maybe
it's
I'm the
like,
only attorney
you
that handles
usually only see them in
objectionable.
Section 8 housing, you know, like
Okay.
ones where there's automatically that kind of.
So thank you very much. I mean, as a council, definitely we will look, I mean, we aim to look for a balance where everybody is taken care of. So we, you know, we'll continue to work on this. We appreciate you coming and talking to us today.
Thank you for having
And,
us.
Thank you very much. Okay, so thank you very much. Thank you, everybody.